Hi, in today's video we're going to talk about the top 3 reasons your family will want to avoid probate court. I'm Paul Bernstein. I'm an attorney, and for over 25 years, me and my firm, the Bernstein Law Group, have helped families in Massachusetts protect and plan for what's most important to them. And in today's video we're going to talk about one of the things clients have talked to us about over the last several decades, and that's probate court avoidance. So before we get to the top 3 reasons, let's talk about what probate court is. Probate court is the governmental process that when someone passes away to transfer ownership of property that was just in their name to the rightful heirs. Probate court does other things as well, but for today's video, that's what we'll be focusing on. I had a colleague that once called probate court, had a little different definition. He said that probate court is a lawsuit you file against yourself for the benefit of disgruntled heirs, creditors, and attorneys. Well, that may or may not be true or have some validity to it, but anyway, let's talk about the top 3 reasons we hear why people would want to avoid this probate court process and certainly not have their family go through it. The first reason is time. What do I mean by time? Well, just to get started in the probate court process and get someone appointed the personal representative, which is the new term for executor in Massachusetts, it takes probably a good month and a half to 2 months just to get through the process to get appointed. And that's assuming no one comes out of the woodwork contesting the appointment or arguing against the person getting appointed personal representative. That's the first component of time. The other component of time is how long can the actual process itself take? There's been many cases we've worked with and certainly heard of that can take years to get through. It's a very public process. That's the second issue people talk about, the public nature of probate court. Anyone can go to any probate court and ask to see any probate court file, and in there will be a lot of personal information as well, not only just who's inheriting what that's going through probate, but what are the value of those assets going through the court process. Now, there's some unscrupulous people out there that do look at most of the court filings that are at the courthouse. And the reason is they're looking for opportunities to go after beneficiaries and try to possibly get at their inheritance. So the public nature is also another factor, another reason to avoid probate. And the third, and certainly not the last reason, is the cost. We never know how much a probate court process will take. We use a rule of thumb to our clients. We say assume it's going to be about 3% of the value of the property going through probate court will go to court costs and attorney fees and possibly executor fees. Massachusetts doesn't state what an attorney and an executor can charge. They just say it has to be a reasonable amount. Some states have set amounts that range from an upper range of 3 to 4%. So never know how much it's going to cost, but often it can be a significant expense. So those are the top 3 reasons that we hear from clients of why they would want to avoid this probate court process. What we often just say is, do you want to have a family-controlled process if something happens to you, or a court-controlled and government-controlled process? Most people we talk to prefer the former, the family-controlled process. They want it to be as easy as possible, private, cost-effective, and move, at their pace, not the court's pace. If you have any further questions or want to just reach out and talk, don't hesitate to contact us. And thank you.